Further hearing in the appeal of Tesco Store Limited against Union of Shop Distributors and Allied Workers and others.
Yes, Mr. Guy Robinson.
May it please the Court, I'd reached finally implied terms. I'm pressed for time, and I apologise for that. Let me start by saying that the principles identified in paragraph 94 of our written case, that's it for your Lordship's note, page 156, those principles aren't in dispute. One of the points that's made, that you would expect to be made, is that implication is only permissible in circumstances of strict necessity. I do have a small observation to make about strict necessity arising from some submissions made by my learned friend yesterday, and that relates to Lord Steen's statement, famous statement in Equitable Life, that one can imply a term where it is essential to give effect to the reasonable expectations of the parties. Lord, it's important to be clear, and I'm sure no one will dissent from this, but I do wish to make it clear, that if the parties reasonably expect something to happen or not to happen, that doesn't of itself justify the implication of a term. Lord Neuberger was alive to this in the Marks and Spencer case, and he dealt with it very briefly. Could I ask your Lordships to go to page 2781 of the bundle?
Sorry,
2781.
Thank you.
It's paragraphs 22 and 23 of Lord Neuberger's judgment. This is where he was dealing with the fact that a large number of very enterprising barristers had taken Belize as authority to argue that, in fact, given that interpretation was all part of one, given that implication was all part of one process of interpretation, and given the emphasis, the reliance that Lord Hoffman had made in Belize on reasonable expectations of the parties, that lowered the test, that made it easier to imply a term. And Lord Neuberger was very anxious to say that's not the case at all. And he says at the end of paragraph 22, there are 2 points to be made about Lord Hoffman's observation that implying a term is part of interpretation. He says in paragraph 23, first, the notion that a term will be implied if a reasonable reader of the contract, knowing all its provisions and the surrounding circumstances, would understand it to be implied is quite acceptable, provided that, one, the reasonable reader is treated as reading the contract at the time it was made, and two, he would consider the term to be so obvious as to go without saying, or to be necessary for business efficacy. And Lord, if I could go down to just towards the end of that paragraph, the parentheses, for the same reason, it would be wrong to treat Lord Steen's statement in Equitable Life that a term will be implied if it is essential to give effect to the reasonable expectations of the parties as diluting the test for necessity. And in my respectful submission, it's important to be alive to that danger in this case as well. Perhaps I could give you an example. The decision of the Court of Appeal in U Design, which is at the end of the bundles, that was a case of a design contract for a property development.
Where is this, sorry?
It's the relevant passage I'm going to take your Lordships to is at page 3578.
Thank you.
That was a case of design services where the designer was to be remunerated in substantial part by a commission or a percentage of the proceeds of sale of the properties that were being developed. And the problem was that the owner ended up not selling them. So the designer was left without a substantial part of the reward that he expected from the contract. In no circumstances he sought to imply a term to the effect that reasonable best endeavours would be made to procure the marketing of the properties, and there was an obligation to sell the properties within a reasonable time. The Court of Appeal firmly rejected that implication, and at page 3578, paragraph 55, Lady Justice Carr said, in any event, a presumed intention at the time of the entry into the agreement to sell the apartments is not to be equated with a presumed intention at the time of entry into the agreement that there should be an obligation on the part of the party to do so. The proposition that the parties wanted and intended to sell the apartments is very obviously correct from the face of the agreement itself. The timeline demonstrates that the off-plan sales were anticipated. It's also not a matter of dispute. The party, the claimant, fully accepts that at the time it entered into the agreement, it intended to sell the apartments. But that is not the issue. The question is whether, as a matter of business efficacy and or obviousness, I said the claimant before, Iliv was in fact the defendant, I'm so sorry, is to be taken to have agreed to an obligation to complete the sale of the apartments and within a reasonable time. The fact that, as you put it, the agreement was all about selling the apartments and fast does not answer that question, it begs it. And I respectfully pray that observation of her ladyship in aid. There are points of my learned friend's argument where he gets very close to trying to do the same thing. If I could move on in my case, this is at page, to paragraph...
Sorry, I'm not quite sure I'm following that precise part of your argument. At what point in the appellant's arguments are they coming closer? I mean, it seemed to me it was entirely accepted that the principles as laid down in the authorities are being applied in this case.
My Lord, let me give an example, a particular instance where there's a danger. My learned friend would suggest, I think he did suggest during his oral submissions, I hope I'm right when I say that, that there was a reasonable expectation that the contract would last for a long time.
I don't think he said a reasonable expectation. I think he says that's how permanent is to be interpreted, a contractual obligation.
Sorry. I may have misremembered my learned friend's submissions. I do believe he relied specifically on equitable life in the context of the necessity of implying.
Yeah, well, he did. Well, it's a good authority, equitable life. No doubt has been cast on it.
Yes. But here, my submission is that there would have been a reasonable expectation that the contract would last for a long time. Why? Because of if Tesco had pressed the nuclear button of terminating all the contracts, all the terrible commercial and legal consequences flowing from that would have provided a profound deterrent for its doing so. There's a reason to expect that not to happen that isn't dependent upon this idea that there must be an obligation in the contract to prevent it happening.
So is it your case that Tesco could, as a matter of contract, have terminated these contracts within days, weeks or months?
As a matter of contract, yes.
Yes.
Let me make one point clear, though. I am not facing an argument that there should be an implied term, such as a dirty trick implied term of the sort that is sometimes discussed in the cases.
But I don't know what that means.
Well, it was discussed by my Lord Legate in Barton Morris. It's often referred to in the estate agency context. There was no suggestion that Tesco had breached a term requiring it not to play a dirty trick, not to act in bad faith, not to act in a way that was deliberately deceptive, for example. Had there been such a case, then there would have necessarily been evidence as to what Tesco's motives were, as to whether it had a good reason for doing what it was doing. But milady, that was not the nature of the case that was brought.
Well, it's a form of bad faith to operate the contract in a way which will undermine the purpose of a key provision in the contract. Well, it's a classic instance of bad faith or a breach of a duty of good faith. One wants to cast it in those terms. With
respect, operating in bad faith would involve deliberately tricking someone.
Well, that's one form of it, but it's not limited to that.
Well, my submission would be in circumstances where Tesco had a really strong, urgent business need to remove retained pay, whatever it may have been. The court has heard a number of suggestions as to what it might have been yesterday. If it had a really urgent need to remove retained pay, it would not be bad faith We're now 17 years after the contract was entered into. It would not be bad faith for Tesco now to be doing that.
But would it... it is your case that the next day Tesco could have, as a matter of contract, terminated these contracts to remove retained pay?
Yes.
Yes.
If my learned friend were to articulate a dirty trick...
No, forget dirty.
Forget
dirty trick, forget bad faith. I'm just asking you whether, as a matter of contract,
yes.
And you say yes.
Yes.
But your point here is that one's got to be careful, as I understand your point, not to elide reasonable expectations with implication by necessity and obligations implied by necessity.
Lord, exactly.
That's your point. Yeah, thank you.
Then turning to the specific, more specific principles adverted to in paragraph 96 of our case, that's at pages 158 onwards. Your Lordships will see at page 158, we cite Ali and Christian Salverson. My learned friend suggested that properly understood that case is not authority for the principle that's cited in paragraph 96.2. I respectfully dissent from that submission. Christian Salverson was a case of an industrial compromise. It was a negotiated compromise across a broad front for a substantial labour force. The court will be aware that so was the retained pay term. 96.3 and 96.4, can I invite the court to read those paragraphs to refresh their minds?
Is there a misprint in the second line of 96.3? I'm not sure I follow it. It's a basic proposition of contract law that if a provision makes an express provision in almost unrestricted language.
My Lord, I think there is a typo. I think the word "and" shouldn't be there. So, and perhaps it would be easier to read if it says, if a term makes express provision. That would be a better way a more elegant way of making the point.
What's the result? Well, it still doesn't make... Well, I'm not sure it makes sense even then.
I mean, I'm not sure I accept that proposition as formulated. In equitable life, the discretion that was being exercised was described in the contract with the policyholders as an absolute discretion. You can't get more unqualified language than that, but it was held to be subject to an implied term, that it couldn't be exercised so as to defeat the guaranteed rights.
Lord, I'm going to come to that, but if I can deal with it quickly now. There is a difference between a discretion properly so-called, where one party to a contract is deliberately given powers to affect the interests of both parties and is expected to act in the interests of both parties. That's on the one hand. In those circumstances, the court and indeed the parties would be concerned to ensure that the party with the power doesn't, who has a conflict, because of course he has an interest in how the power is exercised, doesn't abuse that power for the purpose of achieving a benefit for himself and to hurt the other party.
Well, isn't the power of dismissal analogous?
Lord, absolutely not. I say that what is to be distinguished is between a discretion and an absolute right. Of course, the question whether a contractual power constitutes a discretion or an absolute right is a matter of interpretation. But it has long been established by this court, by many courts, that termination rights are to be regarded as absolute rights that the party terminating can exercise in his sole interests.
Well, do you say that the sickness benefit cases were wrongly decided then?
No, but the reason I was going to come to this rather carefully, but let me go first.
It will have to be careful, because on the face of it, that's an absolute right of termination that isn't, after all, absolute when you construe the contract carefully.
one circumstance in which it is possible to imply a term that would be inconsistent with an express term is where implication is necessary to resolve an inconsistency that already exists in the contract. Now, I say that the PHI cases are cases where there is a promise has been given for sickness benefit, which is to last a particular period. Invariably, it's until death or retirement or the sickness is over.
But the entitlement to the benefit only accrues if you're employed at the time. So on your argument, because the contract can be terminated for any reason or none on notice, you don't have the right to the benefit if you don't have if you aren't employed anymore.
I'm going to come to those cases, but in my submission, and indeed in my submission, this comes clearly from the Awan case. What the court does is it identifies a conflict between the express terms, and it implies a term in order to resolve that conflict. Now, if your lordship takes the view that that's not the basis upon which Awan and the other cases have proceeded, I'm not sure there's much I can say to dissuade you, other than to say that is the way that the court reasoned in those cases. So I'm not saying that there is an absolute rule that one can never imply a term qualifying the standard English legal right of an employer to terminate for good reason, bad reason, no reason at all. And that is a well-established principle of law. But I'm not saying it's physically impossible, logically impossible to imply a term which would qualify that right. But I do say that it only happens in very rare, extremely rare, specific circumstances, and the only circumstance in the cases, in all the cases that are identified in these bundles, is a case where there is a conflict between the operation of, well, between the meaning of an express term and the meaning of another express term, and it's necessary to imply a term in order to resolve that conflict.
And I mean, that goes back to the point that this turns very much on whether we're with you about the meaning of permanence, because if we're against you, there is going to be a conflict.
Yes. I've jumped ahead of myself quite substantially. Could I just, for your lordship's note, an example of the termination right in this case is at page 312. I'm not suggesting your lordships and your ladyship should look at it, but it's there. It's the standard form termination provision. It provides for two forms of dismissal: summary dismissal for gross misconduct and dismissal by notice in all other cases. It's important to remember what that means. That is the well-established proposition that I've already adverted your lordships and your ladyship to. It's set out at paragraph 98 of our written case at page 160. The employer can exercise the right to give notice of termination for any purpose. Those words could have been expressly included in this contract, but if they had, they would have added absolutely nothing to the content of the contract, because it goes without saying. Indeed, if you have an employment contract which doesn't contain a right of termination, the court will imply one. So that is to be distinguished with discretions. Discretions are not absolute rights. The other party has interest to be protected too, and the party with the discretion has a conflict. So to allow the discretion holder to exercise that discretion in his own absolute interests would be to allow him to abuse it.
Can I just ask you, while we've got this open, the terms and conditions, page 308. So these are the the terms and conditions of the individual contract of employment. They don't mention retained pay, is that right?
They do. Well, actually, can I spend a few minutes on that? I've got time. And 300. So, these are individual contracts of employment for the individual appellants.
Yeah.
Your lordship, the one we're looking at is Mr. Webb's contract of employment.
Yes.
I think he was a Daventry man.
Yeah.
Oh no, I'm so sorry, it's not Mr. Webb, it's Mr. Singh.
No, it is Mr. Webb on 308.
308 is Mr. Webb. If your lordship looks on page 309,
Yeah.
under the heading pay,
Yes,
at the top of the
got it now.
page,
Yes,
weekly retained pay. Interesting difference though, if one goes to page 312, that's Mr. Singh's contract of employment, your lordship will see at page 313 there is an express provision for retained pay. Your lordship will also see that it's drafted in a way that's different, the words are different from the retained pay term that we looked at yesterday.
Oh, you can't.
Now, why am I showing you that? I'm showing you that because no one is suggesting that the effect of this term is any different from the effect of the retained pay term. My learned friend's arguments about permanency and so on are based on the retained pay term. This term is drafted differently, but I submit, and I apprehend my learned friend will agree, that it has the same effect. And I do say that's a profoundly significant feature for your lordships to take in, and your ladyship, I'm so sorry, to take into account.
Can I then, sorry to take you off the implied term part of your argument that you're now on, but as we're looking at this, can you just clarify how it is that collective bargains result in changes to individual contracts of employment? I think we may have touched on this yesterday, but I just want to push you on this.
Lord, it's provided for in the collective agreement that your lordship will find.
Well, you can't incorporate something into a contract by, putting it in another contract. I think the mechanism has to be how it gets incorporated into the individual contracts of employment. Maybe there's a term in those that incorporates it, or maybe it's an implied term.
Common ground that there was, by custom and practice, these provisions were incorporated into individual contracts of employment. And your lordship will see at page 321, this is a whistle-stop tour, I do need to get on. It's stopped at the top of the page, it's headed Changing Terms and Conditions of Employment, Negotiating Body. A negotiating body known as the new Contract JNC, that's the Joint Negotiating Committee, will be established that will be the principal body to change the terms and conditions of employment for the sites known as the contract. And then there's a provision as to membership. And if your lordships go to page 322, I really must stop saying your lordships, I'm so sorry.
Don't worry.
Under the heading Objectives, halfway down the page, the objectives of the JMC shall be to give consideration to claims from either side concerning matters contained in the agreement, to consider claims from either side seeking to add, delete or amend items from the agreement. And then over the page, at page 323, halfway down, negotiating process, the JNC shall meet with a view to reaching agreement on the items that will then be placed before the union membership for ballot. These items will be presented in the form of agreed joint statement. And then there's a heading dealing with joint statement.
Yeah.
And then under the heading agreement process, at the bottom of the page and over the page, there's a provision for a secret ballot. And your lordship will see over the page at page 324, confirmation of result, halfway down. A simple majority of those depots voting in favour is sufficient for acceptance and implementation. And I emphasise and implementation. So where the workers vote and the majority votes in favour of a contractual change, it is then to be implemented.
So why can't that be operated regardless of what was put in the retained pay clause? Because
there's a specific agreement in the retained pay clause that makes that impossible. And that's...
Where?
It's common ground, and that's...
Where is it?
It's the provision for permanency.
Right.
There must be no other provision that would have that effect.
So there was a vote by the membership to accept the retained pay proposition, and that vote meant it was incorporated into contracts.
It was incorporated into the contracts that were then being offered to members of staff, and subsequently, when the sites were opened, members of staff would then sign up. It would be perhaps months later, who knows, but it wouldn't be the same time. the vote would occur, it would be put in the relevant contract, and then thereafter there would be parties entering into those contracts.
And you say that if there had been a collective agreement to take away retained pay subsequent to this, you say that would not be incorporated in the individual contracts of employment because of, you've just said, permanence.
They provide otherwise, yes.
Yeah, when you say provide otherwise, if we can just look at page 266.
166.
Is it? 266,
266.
I think. Sorry, I think it is 266.
It is.
My apologies.
Is it your submission that little Roman 1 is the crucial point?
I'm so sorry. Lord, no. My submission is that permanent feature is the crucial point. Little Roman 1 makes it clear, however, that it can be individually negotiated away. My learned friend would say, well, one's good enough. You don't need permanency. That's their argument from redundancy.
Oh.
I say, reading that provision as a whole, including the sub-principles, there's a provision for permanency which is subject to, in other words, which is governed by, which is defined by the following principles, one of which is there can be individual negotiation away. Another is it doesn't apply if you get promoted. And a third is it will be adjusted if you request a shift change that Tesco agrees.
Well, what's the significance of the word only?
My Lord, to make it absolutely clear that it can only happen in those circumstances.
Well, what would be the alternative?
Lord, my learned friend's argument for redundancy may be that the word that only gives him what he wants.
Yeah, well only seems to be excluding a potential alternative.
Lord, what I say is that argument is based entirely on one little word in a clause, which I say it's a practical clause which is intended to give clear guidance as to how it's supposed to work.
But if somebody was looking at this and was saying, what is to stop a
Longer
union
word would have been okay.
by a collective bargain taking away retained pay and that becoming incorporated in the individual employee's contract, they would say, well, that's little one. Retained pay can only be changed by mutual consent. You say that's just, it would be obvious without little one.
I say that the answer would be no, it's a permanent feature. The fact that it's a permanent feature of the contract means the contract can't have that feature removed by any external process, and that is the effect of it being a permanent feature, which is then explained in Roman, the limits of which, the effect of which, are explained in 1, 2, and 3.
But you would accept that 2.1 could do the job entirely?
Lord, I accept that. Indeed, your Lordship will have seen that from Mr. Singh's contract that we've just looked at. But what I say, though, is that if one were to apply a passing approach to this provision, one would overlook its essential function. Roman 2 to 4 are similarly OTOs. Everything is subsumed in little 1. If you want to look at it like that. But what the parties were concerned to do was to explain in very simple terms what can and could not be done. So both defining permanency, explaining what permanency meant, and at the same time explaining the limits, identifying the limits, the boundaries established by the permanency provision.
Thank you.
Well, back to implied term. The question raised by my Lord Legate is that if one implies a term to qualify the unqualified, the absolute right to termination, does that fall foul of the rule against inconsistency? As I've said, if it were a discretion, it would not. The cases on discretion are giving effect to the intention that is to be collected from the agreement. They are not qualifying it. But for absolute rights, it's completely different. If something is an absolute right, they are intended and are allowed to be exercisable in the sole interest of the party for any purpose whatsoever. For the court's note, I would invite you to read the last 2 pages of an article by Mr. Justice Foxton, which is in the bundle at pages 3900 to 3901, and also paragraphs from Lewison, paragraphs 17.107, which is at page 4329. Now that brings me to the Reader case. Your Lordships will, I hope, be familiar with that case. The first point I make about it is that there is no analytical difference between the rights of termination in that case and the right of termination in this one. In that case, there was...
Which is the Reader case, sorry.
If I can invite your Lordship to go to page 3091. This is a case where two senior employees, two senior executives of the company, brought a claim based upon the fact that they had been dismissed in circumstances where the intention to dismiss them was to deprive them of a staff bonus scheme that was about to come in force. And they sought to argue that there was an implied term preventing them from being dismissed for the purpose of removing or avoiding what would otherwise have been the obligation to pay them their bonus. That claim was unsuccessful. It went to the Privy Council. And if we go to page 3091, your Lordship will see, could I invite you to read paragraph 41, which sets out the dismissal, the rights of notice of termination that were provided for in that case. And then having read that, could I invite you to go to page 3092 and read paragraph 45. Lord, I say that paragraph and the reasoning it contains is a rock that stands firmly in the way of my learned friend in this appeal. If the contract contains an inconsistency for which an implied term needs to be made for a resolution of that inconsistency, well, that's a different matter. But outside those circumstances, it would be very rare, in my submission, for an absolute right of termination that's well understood as conferring on the person with the right to exercise it for any purpose whatsoever, for the court to imply a term limiting the purposes for which he can exercise it. Lord, there was some discussion of a similar point in Johnson itself. I don't have time to take the court to it. But if I could invite the court to read paragraphs 37 to 42 and paragraph 43 of Lord Hoffman's judgment, that's at pages 2501 and 2502, the court will see that in that case, Lord Hoffman held that it wouldn't be appropriate to imply in the face of just exactly the same kind of term that we have in this case, not a long form, not for any cause case, but just an ordinary, the standard term that one sees in most contracts of employment. Lord Hoffman held it would not be appropriate to imply a term that right could only be exercised for cause. He then went on to suggest that maybe judicial creativity could allow the right to be exercised on grounds of fairness, but then, because of the parliamentary, the legislative and public policy context, he held that it wouldn't. But I do submit that these authorities do show that one can't blithely treat a contractual power as a discretion and then blithely start implying terms whenever one thinks it would be reasonable to do so. I appreciate I'm putting this in a prejudicial way.
But you do accept, I think, that if the power of dismissal is to be is inconsistent with a term of the contract, then
I accept
an implied term may be.
If the court were to construe the retained pay term in a way that was inconsistent with the operation of the absolute power, then I accept that the court would certainly have jurisdiction and the power to do that. Going back to our written case at paragraph 96, I'll just put my files away. At page 159, perhaps I could invite the court to read paragraph 96.5. I've already addressed the perspective of both parties orally yesterday. I would make a few further points today. It applies to business efficacy as well as obviousness. If the argument is that the contract will not work without a particular term, it must be shown that both parties cannot have intended that it would work in that way, or rather that notional reasonable people in the position of both parties cannot have intended that. And following on from that, even if both parties that there would have recognised that there might have been a problem if it worked in accordance with the express terms, it must be clear as to how notionable reasonable parties would have agreed on how the problem should be fixed. Well, I can't resist taking the courts to Phillips Electronic because it's so beautifully drafted. Could I invite your lordships, the court, to go to page 3018?
18 or 80?
3018.
Thank you.
Paragraph, well, it's the
two-thirds of the way down.
Perhaps it's most of the page.
Hmm.
And then once the court has got to the end of the penultimate paragraph, the penultimate large paragraph, if I could invite the court to go over the page to 3019, subparagraph 6. And then moving on, I hope I'm not going too fast. I know that you'll have read these paragraphs many times before. Last bottom paragraph on the page. In particular, I pray and aid, we question whether in this unusual factual situation, BSB would have been willing to circumscribe its commercial freedom to this extent in advance, no matter what the consequences might turn out to be. In my submission, the court will already have heard me say that it's important to take care about formulating the officious bystanders question. It needs to be neutral, and it also needs properly to articulate the true nature of the obligation or qualification that's to be imposed. We take it in stages. If the question is, would both parties have unhesitatingly agreed that Tesco's otherwise unqualified right to give notice of termination is qualified by the proviso that's alleged, the first problem would be one of clarity. The first reason why Tesco would say, hold on, I'm not sure about this, is one of clarity.
What's unclear about saying you can't terminate the contract for the very reason that you wish to rid yourself of the obligation to pay, retain pay?
Amongst other things, it raises difficulties of mixed motivations, particularly where more than one person is involved in the decision. Let me posit an example. Imagine Tesco has 5 reasons for terminating. Retained pay is one of them. It has a significant influence on the minds of perhaps 3 of the 5 decision makers. Now, in that question...
That's a problem of fact. It's not a problem about formulating the term.
It's a question...
Sometimes there can be difficulty working out whether there's been a breach of the term or not.
But it's relevant in my respectful submission to the question whether a party who it is assumed is being asked to assume that obligation would be willing to do so. A reasonable party in Tesco's position would say, well, hold on, does it mean that I can't do it if it's a significant influence? Does it mean I can't do it if it tips the balance, on a but-for basis? My learned friend suggests the word because of. In discrimination legislation, because of is taken to mean on the grounds of, and that includes the situation where it had an operative influence on the mind. Not the same, not logically the same as but-for causation. So there are all sorts of grey areas imposed by that term. Superficially seems very sensible, and your lordship's quite right. A court could, when asked to answer that question, it could answer it, having heard from the parties, having had them cross-examined, having had disclosure of documents. It could answer that question. But, my lord, we're now facing a prior question, which is whether...
Well, it has answered the question here and found that that is the purpose.
Well, there was no dispute about it. Tesco made it clear they were doing it to remove retained pay.
It's not a very good argument to say that because there can be a dispute about whether there's been a breach in some cases, there can't be an obligation.
I'm not arguing about the facts of this case. What I'm arguing about is whether a notional party in Tesco's position at the time the contract was made back in 2007 would have been happy to assume an obligation of this nature. And what I'm seeking to submit to the court is this is a reason for thinking that it wouldn't. The second problem, as well as clarity, is one of duration. Having asked the question, do you unhesitatingly assume an obligation of this sort, you then have to ask, do you unhesitatingly assume it, even though it could last 40 years, in circumstances which could be very different from the circumstances that obtain at the moment?
Isn't that defined by the express term?
Lord, that, if I may say so, that begs, I'm sorry, this is a really weaselly answer, but that begs the question. If one implies the term that is being proposed by my learned friend, then the implied term would have the effect of applying for 40 years. But if one doesn't apply the term, one just interprets the term in accordance with its proper language, It's simply a statement that retained pay will remain a permanent feature while the contract subsists.
But we only get to an implied term, I thought, if permanent means what Mr. Siegel and his clients say it means.
What I'm submitting to the court is that when any implied term is suggested, the court has to consider the officious bystander.
But if the express term that you are looking at to see whether it's inconsistent with the unrestricted power to dismiss, so as to need to imply a term, the express term deals with duration, as my lord has just put to you.
Lady, my answer to that question is that it supposes, that makes a supposition as to how the parties intended the term, on an objective basis, how the parties intended the term to operate.
But I thought you accepted, if you're right about what permanent means, everything works hunky-dory and we don't need an implied term. It just means as long as the contract lasts, and Tesco can terminate the contract for any reason, good, bad or indifferent.
The supposition on which we're considering the implication of a term is that an express term of the agreement does have that effect.
Well, if the express term has that effect, then there's... I hope I'm not being flippant when I say, where's the need for an implied term?
Well, because there's apparently a conflict in that situation between two express terms of the agreement.
Then in determining how to resolve that conflict, one has to have regard to what notional reasonable parties in the position of both contracting parties would have intended regarding the operation of the provision. And my submission is that notional reasonable party in Tesco's position would never have intended it to operate in this way. And what's more, Usdaw would have, a notional reasonable person in Usdaw's position would have known that Tesco would never have intended it to operate in this way. The burden of expression, if I can use that phrase, would have been on Usdaw to ensure that something was clearly said in the contract, making it clear that what was being provided for was a term ensuring a particular duration of the contract, as one would find in the PHI cases. That brings me to the PHI cases, and I see that I'm pressed for time. Let me make a number of initial observations. First of all, the Aston line of cases, the PHI cases, are cases of implication in fact, where the circumstances are different from this case, I say. As Lord Leggett said in Barton and Morris at page 1297 of the bundle, paragraph 135, it's rarely helpful to argue by analogy in these circumstances. Secondly, in order to ensure, or in order to allow the Aston line, if I can call it that, to apply, the appellants need to identify a general principle that the cases embody. Now, they set that principle out at paragraph 71 and 85A of their case. And for the court's note, that's pages 98 and 103 of the bundle. What they say is, where an employee is provided for benefit as part of the consideration for his work, and in order to receive that benefit, the employee must continue to be employed, then the employer's right to dismiss is impliedly restricted so as to deprive the employee of that benefit. But in my submission, that obviously can't be right. To use Mr. Justice Elias's expression in Genvi, it would turn the law of contract upside down. It would mean, for example, that an employer cannot give notice of termination at common law where he no longer wishes to pay his employees' wages, or he can no longer afford to pay his employees' wages. It would also mean that an employer cannot give notice of termination to an employee who is not sick, but does have a provision for sickness benefit in his contract.
Well, the principle was only if the right had accrued or was accruing.
Exactly.
So,
but the principle that my learned friend advocates is a principle that would apply even in advance. It would there is a benefit provided for in the contract.
a future benefit.
A future benefit. It's part of the consideration that the employee receives for doing his work.
Well, then it's not a future benefit if it's part of the consideration. Do you mean a future benefit as consideration for current work?
His right to receive...
But that's not what those cases establish. Those cases establish that the right must have accrued or be accruing.
Well, that's the point I'm trying to make here. Perhaps I'm not being clear.
So here, retained pay is accruing. They are all in receipt of retained pay. They've all made arrangements financially on the basis of receipt of retained pay, and that's what they're living on. So why are we worried about future considerations?
What I'm seeking to address is the proposition advocated by my learned friend, the principle that he seeks to derive from the cases, that there is a general principle that where a contract provides a benefit, an employer can't terminate the contract in order to remove it. Right. And I'm saying that there is, even in the PHI context, there are circumstances where the employer can. Mm-hmm. That brings me to AWAM. I hope I'm pronouncing it right. It's in the bundle at page 1140. I won't recite the facts. It's a PHI case. And it's my Lady Simba's judgment, of course. Paragraph 49, which is at page 1153. Could I invite the court to read that, please, and also paragraph 50. At the end of paragraph 50, her ladyship said, "Those terms are clear, but I do not accept that they are not inherently contradictory." So what was found was a contradiction which needed to be resolved by the implication of a term. And then her ladyship continued in paragraph 51, "The express power to terminate is in general terms. It does not expressly deal with incapacity, as the clause in Aspden did, and it does not expressly reserve a right to dismiss without cause, as the clause in Reader did." Stopping there, it's true that the clause in Reader expressly provided without cause, but I say that made no difference. It didn't need expressly so to provide. But the contract also includes an express term that disability benefits, once payable, will continue until death, retirement, or a return to work. There is no reference to dismissal for incapacity in Clause 6 or Section G of the booklet. If, as the tribunal concluded and the respondent contends, the respondent was free as a consequence of Clause 11 to terminate the contract on notice, while entitlement was to disability benefits was ongoing, the unequivocal entitlement in Clause 6 would be deprived of its content.
So the analogy here, do you say, would be if the retained pay clause had said retained pay will continue until retirement?
Exactly. If the clause had said you will continue to receive retained pay until death or retirement, then there would
you wouldn't have an argument.
Exactly the same way. Right. However, the clause doesn't say that. I mean, if I could take another example, there's a contract providing for the payment of a wage. I ask forensically, rhetorically, would that contract contain an implied term necessary to ensure that the employee receives his wage, that the employer won't terminate in order to stop having to pay the wage? Answer, obviously not. Then I asked forensically, would it make a difference as if instead of simply saying the contract, I agree to pay you a wage, instead the contract says this wage will be a permanent feature of your contract. Would that change the situation? And my respectful submission, obviously not.
Doesn't it depend what permanent means?
It does. I do accept that my case rests very heavily on that question. And then paragraph 52, your Ladyship said, so rewritten, the entitlement ceases to be an entitlement at all. There are no circumstances in which the respondent will be contractually obliged to pay disability benefits in the long term if it preferred not to do so. And then your Ladyship added, and no reason to think that it would ever do so. Lady, that's not the position in this case. There are all sorts of reasons to think that Tesco would wish to do so. And indeed, Tesco did do so for 10, 11, 12 years. Longer than that, I'm so sorry, 14 years. The terms are inherently contradictory. Either the claimant has a meaningful entitlement to disability benefit until his return to work, death or retirement, or the respondent had an unfettered right to terminate his contract on notice at any time, even for incapacity, but not both. So there, what the court did was identified a binary, two alternatives. In the absence of an implied term, there would just be no meaningful content to the term. It would give the employer a free option to avoid having to pay disability benefit. I respectfully submit that this case is completely different. There are all sorts of reasons which the parties would have known about at the time, from which it can be properly inferred. In fact, from which the only inference is that Tesco had an extreme incentive to ensure that it would continue paying retained pay for a considerable long time, that retained pay would have longevity, if I could use that word, including the threat of unfair dismissal if that wasn't the position. And then paragraph 55, the court said, I fully accept that terms should not be implied too readily and that court should tread warily in this area. I hesitate to put words into your Ladyship's mouth, but I venture to suggest that you had in mind precisely that the court should be slow to imply a term restricting the absolute right of termination that applies as a matter of general law. However, this is a case where the contract was known by both employer and employee to include a disability insurance plan, which could only work if the employees eligible to receive such benefits remained in employment for the duration of their incapacity. The contract of employment is inherently contradictory. Lady, I say, may it please you, I say that this contract could certainly work, and indeed did work for 14 years, without the implication of any term. And I also say that there is no inherent contradiction in the terms in this case. And then your Ladyship says, it seems to me that in a proper construction of the contract, it's contrary to the functioning of the long-term disability plan and its purpose to permit the respondent to exercise the contractual power to dismiss so as to deny the claimant the very benefits which the scheme envisages will be paid. In my judgment, a term can be implied. I dissent from, if I may respectfully say so, I accept all of that. Awan is correctly decided in accordance with the correct principles. And it was a case where one could certainly, in imposing both the officious bystander test and the business efficacy test, both of those tests produce that result. But I respectfully submit that this case is different. That case was an if-then contract. If you fall ill, then after a certain period of time, you will receive these benefits until death, retirement, or you get better. The contract in this case is not that kind of contract at all. One can see in an if-then contract that for there also to be a term that, as well as you having this entitled to benefit, in the same circumstance, I also have a right to terminate you, that would be contradictory. there's no contradiction in my respectful submission. Of course, if the court is against me on true construction, then there it is. But that's my submission. My learned friend also relied on Genvi, but I see the time.
Sorry, the point about it being an if, I mean, it would presumably be said against you here if you remain employed in the same role at Tesco, you will receive retained pay. We're querying, you want to say, subject to 3 months' notice within the confines of the contract, but it's being said against you that in effect, although it's not spelt out until retirement or death in quite the same way as it was in the permanent health insurance cases, that is effectively what one has.
Lord, I see the point, and I accept if my learned friend's constructions is, if the court is persuaded by my learned friend's construction, then some of the arguments I've made won't find favour with the court. But I would say this, it's really to repeat the example I gave. The clause in this case was a clause that retained pay, where you've got retained, there's a provision for retained pay, and there's a description of the nature of the right of retained pay. It's that retained pay will remain a permanent feature of the contract. It's like a clause that a wage will remain a permanent feature of someone's contract.
We don't need to say that. It's part of the contract. So of course it will remain a permanent feature of the contract.
One might need to say it if there were a concern that the right could be removed by way of collective bargaining. And it's common ground that there was a desire to include a provision in this case to remove the right of removal via collective bargaining, or the prospect, I should say, of removal. So, in conclusion on implied terms, I say the construction of the retained pay term is clear. I'm so sorry. There's one further point I should deal with. It's something I told my Lord Reid yesterday that I would deal with a particular pre-contractual document, and I realised to my horror I failed to do that. So can I go to that now? It's at page 277.
277.
277.
This is the protection for life document.
Yes. Now, this is my submission, an odd document. The evidence, or the document itself, suggests that it was provided to employees at Crick because it refers to Lichfield in the heading on the left-hand side at the top. But we don't know by whom it was provided or when. There's no evidence of those questions in the bundles. It says, new terms and conditions supported by individual retained pay, dash, protection for life at a new Tesco contract site. Obviously, not literally true. Begs the question, life of what? I say life of the contract, if one is applying principles of construction, not life of the role. It might be said, well, life at the site, so long as whenever you remain at the site. Well, that can't be right. That's certainly not what was intended, because it wouldn't apply if you were promoted at the site. It's not literally true. And why do I say that's important?
What about for the remainder of your employment with Tesco?
Well, that would be inconsistent with the retained pay term. You can remain employed, but be promoted.
Well, but
yes,
nobody's going to accept a promotion at a lower pay level than what they're getting, including retained pay. if you've got retained pay that takes you to £100 a week, you're not going to accept a promotion that gives you less. So the retained pay will implicitly continue, but in a pay package that's no longer termed retained pay, it's termed £120 a week.
In my submission, we're I have to. It's my job, and I've said I would. But we're paying far too much care and attention to this term. This document is a flimsy document.
The judge found it was produced by the defendant, given by the defendant to its employees. Paragraph 9.
There is no evidence of that before the court. She was told that by counsel, and Tesco wasn't in a position to contradict because it didn't know. But I do say that it would be wrong to subject this to overly long and study for several reasons. First of all, one goes to the bottom of the page. It says, please refer to previous joint statements for details. This is not a document which purports to give the details of the... You have to look at something else to see what the detailed agreement is. It's just a headline. And like as with most other headlines, you would expect it to be inaccurate. It's nothing like, in my submission, the sort of explanatory documents that are considered in any of the cases, a booklet by, which is attached to the contract, or even a circular which is published with a view to people entering into the contract understanding what it means. It's not like that.
Well, Mr. Hoggan's letter wasn't a previous joint statement, but it was issued on behalf of Tesco's, and it used the expression for the remainder of your employment with Tesco.
This is the letter.
Yes.
Lord, that's right. It did say that. What I say is, where you're... in a way, that makes an important point. It says for the remainder of your employment. It doesn't say how long the employment will last. There's no promise of no dismissal. It's simply, so long as you're employed, you'll get it. But that's not a promise that there will be no dismissal. It doesn't make any representation as to how long the employment will last. I agree that this document is admissible as an aid to identifying the aim or objective. But it does not mean that it should be treated as a substitute for the contractual terms, or as if it were part of the contract. That would be the wrong approach in my submission. And if I could invite the court to go to page 150. These are our submissions. Paragraph 76.4 of our submissions, if I can invite the court to read paragraph 76.4. Where it's appropriate to have regard to explanatory notes, such notes cannot override or qualify the clear meaning of the contractual terms. I say the contractual terms have a clear meaning. Permanent feature cannot mean it doesn't involve any statement as to how long the contract will last. It's just a permanent feature of the contract. And then 76.5, as Lord Phillips emphasised in the Tyche, before taking extrinsic evidence into account, it's important to consider precisely why it's said to assist in deciding the meaning of what was subsequently agreed, and to consider whether its relevance is sufficiently cogent to the determination of the joint intention of the parties. I say this is not cogent evidence. It's a flimsy document, the kind of thing that one might have pinned up on a notice board, but not the kind of document on the basis of which one is going to decide to enter into a binding contract. One would look at other documents for that purpose. Joint statements, I accept, and if the court finds joint statements contain statements that are relevant, they have more weight. But I still say they're not a substitute for the contract, and they aren't to be read as if they're part of the contract. The contract still has to be construed in accordance with its own terms. It's only if it's an available construction of those terms that the contract can be given a different effect.
So are you actually saying that the document at page 277 is inadmissible.
Oh no, I'm saying that it is of
Limited weight.
very limited weight. That leads me to deal with the injunction. I must go quickly. Let me start by identifying what I think is common ground. As I understand from my learned friend yesterday, I think 3 propositions are agreed between the parties. First, an injunction to restrain dismissal is an injunction which entails indirect specific performance of a contract of employment. Second, the general rule is that injunctions are not granted where they involved indirect specific performance of a contract of employment, whether interim or final. Thirdly, this is a general rule, not an absolute rule. There are exceptional cases where injunctions have been granted in those circumstances. They are few and far between, but it's common ground that they exist. The question for this court is whether this is one of those exceptional cases.
Well, do you accept that the underlying principle is whether there's been a loss of trust and confidence?
No. Lord, I say that's a factor, but by no means the only relevant factor. 2 small points about the history, how we got here. First of all, my learned friend's not quite right when in the account that he gave of the issue and how it arose in this case. At first instance, the claimants argued for an injunction because damages were not adequate. The judge agreed because she held that if the claimants, she held that there was an implied term, but she also held that if there was a breach of that implied term, it was subject to the cap that's imposed on unfair dismissal awards. And for the court's note, that's paragraph 55 of her judgment at page 238.
Sorry, what paragraph?
55. I must, because of the limitations of time, I'm afraid I must go on. That was obviously wrong. Ex hypothesi, a claim for breach of the implied term would be a contractual claim, and it wouldn't be capped at all. So it meant that her finding that damages were an inadequate remedy was open to challenge. That finding was challenged on appeal. The claimants did not grapple with that problem in the Court of Appeal, so far as I can recall. But the judge's obvious error, unfortunate but obvious error, meant that the Court of Appeal had a discretion of its own. My learned friend relies on all sorts of cases, quite proper cases, indicating that where a court has the discretion, an appellate court should be slow to interfere. I respectfully agree, but that helps me, not him. Second point about history, I don't say this is a complaint, but it's important to recognise in my submission where we are. The case that was advanced by my learned friend yesterday is that this case is effectively equivalent to Hill and Parsons and Powell and those cases. That is not the case that he made in his written case. The appellants do not cite Hill and Parsons or Powell or Chabra. They don't mention trust and confidence. These are cases, and these are the principles that Tesco drew to the attention of the court in its own case in response.
Well, they've relied on this now, so
Yeah.
Oh, absolutely.
They've seen the benefit of your submission.
Yeah.
I'm so happy that I was able to assist my learned friend. Let me deal then, with that background, let me deal quickly with 4 issues. First of all, why does the general rule exist? Secondly, what are the exceptions to it? Thirdly, how should the court proceed here, dealing at that stage with the points raised yesterday about Part 8 claims and avenues for to deal with difficulties? And 4, what is meant by adequacy of damages in this context? First of all, why does the general rule exist? The general rule, there are exceptions, is clear It's nicely articulated by Lord Justice Bean in Steer and Stormshaw at page 3299 at paragraph 1.
Paragraph
1
Thank you.
of his judgment. As law students, we all grew up having this point dunned into us: employment contracts aren't specifically enforceable. The central proposition is that an employer should have the prerogative to decide who remains in its employment. Why? A significant part of the reason is because employment is a relationship founded on mutual trust and confidence. But, and this is a point of importance in my respectful submission, it's not the only reason. Not just a question of whether one has justified suspicions or concerns about the conduct or capability of a particular employee. There are more fundamental points also at play. If an employer does not wish to employ someone at all or on some particular terms, the court would not ordinarily force them to do so. To do so could lead to friction and distrust. And that is not a workable foundation for a productive relationship. Another point is one of mutuality. It's well established as a matter of statute that injunctions against employees are not available. And if you can't enforce a contract against the employee, the question would arise forensically, why is it right for the court to enforce the contract against the employer? And there is also the question of adequacy of damages. And I pause to note that these considerations apply just as much to large employers as they do to small. There is still a relationship which involves human beings working together. And of course, the court will be well aware that in the employment tribunal field, it's not possible to make to compel an employer to take someone back on. So that's the general rationale for the rule. What are the exceptions to it? There are a small number of exceptional cases where injunctions have been granted, and in many of those cases, a feature has been that there was continued trust and confidence between the parties. But I emphasise 3 points. First, there are a very small number of cases. Secondly, the cases are overwhelmingly interim cases. This is not a technical objection. In my submission, it's important to recognise that it's far more likely to be appropriate to issue an injunction on an interim basis, holding the ring, than it would be to issue a final perpetual injunction. And even with the interim cases, it's important to be careful in looking at the terms of the relief actually granted. If I could take the 4 cases that my learned friend identified or founded his argument upon yesterday, they are Hill, Powell, Chabra and Jones. In my submission, in none of those cases did the court order permanent relief preventing the giving of ordinary notice to terminate. In none of those cases was there actually an argument that at trial such an order for permanent relief would be given. They were different. These cases, the facts of those cases were different. If we could start with Hill and Parsons at page 2325. First of all, let me start with the injunction itself. It was an interlocutory injunction at page 233 at letter C. Sorry,
2-3.
I'm so sorry, my noting system has gone haywire. Would your lordships give me a moment?
Hill and Parsons does start at 2325. It's the one that starts
2336. I'm so sorry, Lord.
336.
he says, Lord Denning says, just below the letter C, I would allow the appeal accordingly and grant an injunction restraining the defendants from treating the notice dated July the 30th as having determined the plaintiff's employment. Now, the basis upon which he did that was that it was held that the period of notice that ought to have been given was much longer than the notice that the employer had given. And so the injunction that was granted here and would have been granted at trial, might have been granted at trial, was an injunction simply saying that you can't rely on that notice of termination. There's no injunction restraining the employer from giving a further notice of termination for the right period. And one can see why the injunction was granted. If one goes to 2335 letter B, Lord Denning says, why does the length of notice matter so much in this case? You might think that if the first notice is bad, the company would now be able to give another and so get rid of Mr. Hill a few months later. Lord Denning's answer to that question is at letter G. The net result is this. If the notice given to Mr. Hill is effective to terminate his employment before Part 2 of the Act is brought into operation, he will have to leave his employment and get little compensation, just 3 months' worth of notice. But if it does not take effect until after Part 2 is brought into operation, he will not have to leave his employment, nor will he have to join the union, data. He will be able to stay on until the normal time for retirement. Hence the importance of this case to Mr. Hill and to the 37 other professional men who stand with him. So the injunction was granted because if the employer was forced to issue a new notice of termination, perfectly entitled to do so, but the result would have been that Mr. Hill and his colleagues would have been entitled to all sorts of protections, statutory protections, which this early termination had deprived them. So
that's because it was just before the Industrial Relations Act 1971
yes.
came into force. Yeah.
And if we go to page 337 at letter F, this is the judgment of Lord Justice Sachs. He makes the same point. It follows that before any lawful notice of the plaintiff can expire, not only will closed shop agreements of the type that the defendants have made with data be no longer valid, but data itself, if our information is correct, will probably not even be eligible to enter into an agency shop agreement within the meaning of that phrase. And then, if one then goes over the page
and was this dismissal designed to, was it given specifically to avoid those rights?
I don't believe there was any evidence to that effect. I don't recall that in the judgment. It was simply that it happened to have that effect. And then if one goes to 2338, picking it up from the letter A, if the relevant provisions were held to be applicable, it would seem to be a case where a recommendation for reinstatement would be made, which, if not implemented, would be followed by an award of compensation, much in excess of any damages recoverable at law. Taking the aggregate effects of the above-mentioned provisions of the Act of 1971, it appears that by the middle of April 1972, it would be highly unreasonable for the defendants to maintain that there was any good reason stemming from their agreement with data to cease to employ a loyal employee in whom they had complete confidence and who had been with them for over 35 years. It would indeed seem probable that if the plaintiff's contract continues to subsist until such time as he will in practice be retained thereafter in the service of the defendants, until in due course he reaches the age limit normally applicable to his appointment. And then the court will see at page 2340.
Surely the reason why they were getting rid of Mr. Hill and the others was because they refused to join the union.
That's quite right. And what's more, the employer didn't want to lose him. And you're, of course, my learned friend is entitled to pray that point in aid. But what he can't say is that this raises some presumption or some principle that if trust and confidence subsists, then there's a prima facie right to an injunction. It doesn't work like that. Even in that situation, there will be factors which the court has to consider.
But he can say that this is a case where you don't want to lose the employees because you are offering to re-employ them.
Yes, it can. But I can also say that the injunction in this case is nothing like the injunction in Hill. This is not a case where I've simply issued a solitary notice of termination and I'm being injuncted from acting upon it. The injunction in this case would apply for the next 20-odd years or more, and it would potentially apply to all notices of dismissal that I make. By which I mean, obviously, if a dismissal is made that's not in breach of the injunction, then there wouldn't be a breach of the injunction, provided that the evidence could show that. But nonetheless, it potentially applies to everything, all future activity, whatever the circumstances, including, one can imagine circumstances where there is no longer. Right now there's trust and confidence, but one can't assume that forever. There may be really good reasons why.
Well, it doesn't stop you getting rid of somebody for good reason, who trust and confidence has broken down.
Well, that's when we get into the mixed motives problem again. Imagine a situation where Tesco has a really good reason. He's really cross with these employees. They've been very bolshy, but I'm sorry to use that language, but really difficult in relation to this dispute. That it's people are getting very angry, and Tesco has enough. I'm not suggesting that Tesco is the kind of employer that would do this, but I'm just trying to explain how possibilities that could arise.
Well, do you have a narrower version of the injunction as an alternative to propose if we're against you in principle, and the objection is simply to the fact it goes too far?
Lord, no, I say it goes far too far, and that as a matter of principle, it raises inherent problems which can't be cured on my submission by clever drafting.
Thank you.
But let me develop that submission.
You couldn't restrict it to these particular notices of dismissal, as in
exactly.
Hill. Hill is a case that gives a very clear, narrower version.
Well, no notices of dismissal have actually been given in this case.
No, but the injunction could be restricted to this scenario, these facts.
What has been done? There's presumably been some letters sent or to the employees, is there? Or?
Yes. The evidence shows that letters were sent saying what we're proposing to do is this. If you agree, we'll pay you 18 months your retained pay entitlement, and then the retained pay goes.
And they could be enjoined from
Acting on them.
From that, exactly, dismissing them pursuant to that proposal.
That assumes that the only consideration that the court has to take into account is whether trust and confidence is subsisting. It's not the only consideration that the court needs to take into account. What about other considerations, such as the burden to the business, of the sort that I discussed yesterday? The effect of this injunction would be to make them irrelevant. That would not operate as a reasonable excuse. What if Tesco wanted to close down the site because it was expensive to run?
But that isn't this case.
At the moment, it's not this case.
No, well, so what's the objection to an injunction of the kind my lady suggested that's targeted at this situation?
But it would still be perpetual. It would still last 40 years. And the problems would arise.
Why? It wouldn't. An injunction that prevented Tesco from acting to dismiss pursuant to the offer letters that were sent out in
whenever they were
2021.
Well, lady,
what doesn't stop you in 2025 or 2026 for a reason unrelated to retained pay from making redundancies or whatever else?
But there's the rub. The problem is that in no circumstances, the Tesco may have very good business reasons. It may need to remove retained pay.
Well, it wouldn't actually stop you trying the same thing again. But our decision would be likely to prompt, if we're against you, an immediate application for a new injunction.
Yes. I mean,
but then you'd be able to say, well, there's special circumstances which mean that trust and confidence, whatever's now different circumstances, so an injunction's not appropriate this time round.
I respectfully submit that My learned friend, that's an application that I've never faced before. So I must admit I respond with some surprise to the suggestion that a completely different injunction should be granted. I do respectfully submit that.
Well, if you say it's all or nothing, then perhaps then you may end up worse off. I was just exploring whether there's some lesser injunction that might meet one concern, even if it doesn't meet others.
In my respectful submission, what is sufficient to meet the justice of this case is a declaration as to the parties' rights. No injunction is needed at all. And in many ways, the suggestion that my lady helpfully made, I say helpfully, of course I don't mean that, to the effect that there could just be an injunction in relation to the particular notices that were sent 2-3 years ago now. That demonstrates the point that no one is acting on that anymore. That's history. The injunction hasn't been enforced for some time. But the point is that if there's I ask forensically, what is the reason why an order, with all the consequences that an order would have, is needed to be made against Tesco?
And if we are with Mr. Siegel on the substance of the case, but with you on remedy, and we grant a declaratory remedy, then presumably Tesco would then dismiss the employees and they would have remedy and damages.
Yes.
Yeah.
I was going to go through Powell. I see.
And if there was an injunction, no doubt the practical reality is that Tesco would just bargain out of it and pay more. I mean, this is what normally happens, isn't it?
I couldn't answer that. I'm not in a position to answer that question. I think I don't have the courage to try.
Well, the injunction might in a way suit them if they are faced with equal pay claims.
The injunction would... well, I was going to take your lordships, the court, I'm so sorry, to Powell and Jones and to Chabra. May I say some very brief things about those cases? Not actually going to them. I see that time is running short. But make some submissions and to answer any questions that arise. Then to talk about Tesco's position, and it may have a bearing on some of the suggestions that the court has made in the last few minutes. Powell and Brent, for your notice at page 3043 of the bundle, at page 3046B, Lord Justice Ralph Gibson noted it was a most unusual case. The claimant had been appointed as a principal benefits officer. She'd been promoted to the position of principal benefits officer. A few days after starting work, she was told that her appointment was invalid because the authority had breached its equal opportunities policy in appointing her. There was a dispute as to whether she had or hadn't been effectively appointed. By the time of the hearing, she'd been doing that job for at least 4 months. The interim injunction that was granted was that she should be treated pending trial as if she was employed in that role, that promoted role. So it's not a case about dismissal. The injunction was not concerned with preventing Brent from dismissing. The case was about whether the Brent should be required to treat her as employed in the more senior role in which she was already working. And for the court's note, that's at page 3045, letter H, and 3051, letter G. The rationale given for the injunction is that you can see it at 3060, letters G to H. Ordinarily, the fact of opposition is sufficient to prevent an injunction being granted. But then let's see what Lord Justice Ralph Gibson then says. Perhaps I should go to this. Could I ask you to go to page 3061, letter B? reference to Hill and Parsons being an exception to the rule that the court will not by injunction require an employer to let a servant continue his employment when the employer has sought to terminate that employment and to prevent the servant carrying out work under the contract, unless it's clear on the evidence not only that it is otherwise just to make such a requirement, but also that there exists sufficient confidence on the part of the employer in the servant's ability and other necessary attributes for it to be reasonable to make the order. I appreciate that sounds like a statement of the blindingly obvious, but it is important in my submission because justice, the interests of justice are often triggered and feature very heavily in questions of specific performance of enforcement of employment contracts. And if one looks at the factors, the Lord Justice says sufficiency of confidence must be judged by reference to the circumstances of the case, and then he identifies a number of relevant considerations, including at the end of that paragraph, the likely effect upon the employer and the employer's operations if the employer is required by injunction to suffer the plaintiff to continue in the work. Now, the consequence that he had in mind there was obviously disruption, but there are other consequences that also need to be borne in mind.
Like what?
Well, the consequences that I was adverting to at some length yesterday.
The equal pay consequences.
And possibility of the difficulty of redundancy as well. So this case isn't authority for the proposition. I think that my learned friend sought to rely on it for, that once one can show trust and confidence, one sort of has a presumptive right to an injunction. The injunction here wasn't an injunction against dismissal anyway, but even if it had been, it was a case where the court was very careful to make it clear that it's not just about trust and confidence. There are other factors that need to be taken into account as well. And your lordships may find it instructive to read what Lord Justice Ormrod said about the injunction at page 3067, where he makes the point this isn't about dismissal, and lots of the argument has gone off in the wrong direction as a result. I then come to Chabra. Chabra was a case where it was held unlawful for a trust, an NHS trust, to proceed with a disciplinary procedure in a particular way. The injunction granted prevented the disciplinary panel that had already been constituted from considering certain allegations as matters of gross misconduct. The court will get that from page 1642, paragraph 42. It's not analogous with our situation at all. It's a one-off. It was a final injunction. This is the only final injunction that's relied on. But it was a final injunction simply saying that disciplinary procedure there cannot treat a particular allegation as an allegation of gross misconduct. That's all. It wasn't a disciplinary. I'm so sorry. It wasn't a dismissal injunction, although of course, in practice, there would have been no dismissal until this disciplinary process had been completed. Final case, Jones and Gwent County Council. That was a case where Mr. Justice Chadwick, really, it has to be said, took against the employer council. It was an application for an interlocutory injunction, but the judge, it was a disciplinary case actually. There was a proposal to have a third disciplinary hearing against the claimant. And on an interlocutory application for an injunction pending trial, the judge decided to treat the application as an application for a declaration under Order 14A, I imagine to the horror of the defendant's counsel, and held that a notice of dismissal that had already been made was invalid because it was in breach of the contract. And so he granted an injunction. This was a final injunction, restraining the council from treating her as being dismissed pursuant to the invalid notice. Again, that wasn't a perpetual injunction that could last another 20 years, whatever the circumstances. It was just about a particular piece of paper that had been served, and it reflected the fact that that piece of paper had not been served in accordance with the contract. So if I can stand back, none of the cases relied on by my learned friend come anywhere near this one. This case would not be an incremental extension to about issuing perpetual injunctions. It would be, in fact, a giant leap. What the cases emphasise is that you need an exceptional case, and you should only grant it where it's just, and there is also sufficient confidence in all the circumstances. And you take into account the effect on the potential effect on the employer of the granting of an injunction. I was going to address the court on impact, but I see that I only have 5 minutes left. Let me therefore just advert the court to 2 further points. First of all, there is in my submission, very helpful discussion of the practical considerations that arise in this sort of context in cooperative and Argyle stores. That's at page 1643 of the bundle. And I invite the court to read pages 1654 letter G to 1655 letter D and 1655 letter H, 1656 letter F to 1657 letter B. I'm so sorry to give you this algebra alphabet, and 1657 letter H to 1658 letter B. That was a case that involved an application for a final order for specific performance, requiring a supermarket to maintain a business in a shopping centre in accordance with an express covenant in the lease. And the court, the House of Lords, refused to do that. In the course of doing so, Lord Hoffman helpfully articulated the principle that you don't get specific performance if damages are adequate. That's point number 1, and I say that principle applies equally to this case. But secondly, he also considered the reasons why it's inappropriate to make such orders, including, for example, the fact that it's wholly inappropriate to enforce them by way of contempt proceedings. That is entirely inappropriate. They can require successive applications to court in circumstances where there are arguments about how it should operate or whether there's been a change in circumstances. And that falls foul of the constant supervision rule. And also that it imposes an inappropriate burden on the defendant and an inefficient burden on the defendant, because should the claimant be restricted to his claim for damages, he has a duty to mitigate. Whereas with an order for specific performance, you can end up making an order which imposes a burden on the defendant which is out of all proportion to the benefit to the claimant. And that's an important consideration to bear in mind. I respectfully submit that all of those considerations apply in this case. Lord, I only have time, I think, to deal with the suggestion that was made yesterday in relation to the possibility of alternative avenues, that my learned friend called them. One was the suggestion of a Part 8 claim by Tesco. Another was a suggestion of an application to vary or discharge. On the first suggestion, it wouldn't be a Part 8 claim, it would be a Part 7 claim, because there would be issues of fact, what Tesco's purpose was. There would be disclosure, there would be witness statements, and there would be cross-examination, and there would be a trial.
But even if it were Part 8, this was Part 8, and we've taken 3 years to get to the Supreme Court.
Exactly. It's exactly why Lord Hoffman was saying it's just not appropriate to have these kind of mandatory orders in these kind of cases. The suggestion of an application to vary or discharge, the power to vary or discharge would arise only where there's been a change in circumstances. First problem is, it might be said by the respondents, well, let it be assumed that one of the reasons that I averted to yesterday was the reason why Tesco felt that it needed to move. It might be said, well, that's all foreseeable, all completely foreseeable. Why didn't you argue that out at the time? Secondly, such applications are problematic. We sent over this morning a case of Investbank and El Husseini. I don't know if the court has managed to receive it. I won't take you to it, but that was a case where the bank obtained undertakings in a freezing order form over the assets of the sixth defendant, who was called Joan. Joan subsequently gave notice of her intention to draw on frozen funds to meet her living expenses because she'd exhausted her unfrozen funds. The bank objected, alleging that she had funds available in another country. Facing a threat of potential contempt, Joan applied for a declaration that she had no other means than the frozen funds. That was by way of interlocutory application. And after a number of volte-faces, the bank initially said that was inappropriate. The bank then made an application of the same sort. Mrs. Justice Dias refused the bank's application, and her reasons for doing so are, in my respectful submission, pertinent. They're to be found at paragraphs 22 to 24. First of all, 22, she says, I'm quite clear that it would not be appropriate for me to make any determination one way or the other as to whether Joan does or does not presently have other means to pay. But 23, she said, even if I only made determination on civil standard of proof, I would effectively be making a finding on untested evidence in circumstances where the primary sanction for breach of a voluntary undertaking is an application to commit, with all the concomitant safeguards that entails. In my judgment, it would be wrong in principle to do that without giving both sides an opportunity to test the evidence by cross-examination in the light of disclosure. And then at 24, she said, any determination I made could only apply to the situation as it exists today. That might change tomorrow or next week. I was going to address the court on adequacy of damages, but I fear that I trespass on your patience already too much. My simple submission in relation to adequacy of damages is that one sees in the interlocutory cases statements that my learned friend took the court to yesterday, but in question of final orders for specific performance and injunctions, the general rule is damages are adequate unless it's really impossible to quantify them. Perhaps I could just invite the court. We won't have time to go to it, but if you're...
Well, there are cases where difficulty of quantification has been accepted.
There are. There is a question of degree.
Yes.
I accept that. In my submission, the difficulties here are not sufficiently profound to trigger the principle. This is one of those exceptional cases where difficulty of assessment would be a barrier to damages being treated as adequate. And if I can invite the court simply to read Snell, it's in the bundle at page 4331, and read between 4336, well, perhaps read page 4336 and the first sentence of page 4338. And it cites Fothergill. Fothergill is a case that's in the bundles. It's at page 2091. And I haven't trespassed on your patience too much.
Thank you very much, Mr. Garr-Robinson. Mr. Siegel.
My lord, yes. 7 minutes late, but I'll do my best.
Well, you overran a few minutes yourself yesterday.
Sorry?
You also overran by a few minutes yesterday.
Oh.
It was 10.
I was 10 minutes late starting. That's a little unfair. But anyway, it was meant to be a jest, not a serious point. The promise that retained pay will remain a permanent feature of the claimant's contracts means, per se, just that. If they reject redundancy pay and opt to move to the distribution centres, they will remain entitled to retained pay for as long as their contracts continue. In the same way that Mr. Awan, once he qualified for long-term disability benefits, was entitled to be paid them for as long as his contract continued. However, and this is where the respondent's analysis falls down, in both cases, other events could happen which could bring a premature end to that entitlement. In Mr. Awan's case, he could fail to produce the required medical evidence, or he could recover. In the claimant's case, there are 2 specific events provided for by the retained pay term. They could get promoted, or they could choose a different shift pattern. Remaining a member of warehouse staff was a precondition for being entitled to retained pay, just as remaining incapacitated was a precondition for Mr. Awan's entitlement. In both cases, if the precondition ceased to apply, the entitlement ended. The statements issued by Tesco covered the extent to which the entitlement was permanent, and they also covered the circumstances to which that permanent entitlement was subject, as did the final agreed wording of the term. What my learned friend did yesterday was to conflate the basic permanent entitlement and one of the qualifications to it. So, at page 271, the letter that assured workers that Tesco will protect the value of your existing contractual terms and conditions for the remainder of your employment with Tesco, that concerned the basic entitlement that retained pay would remain a permanent feature of their contract. It does not address the qualification to that, but it attached a question and answer. And at 272, question 6 summarises both. Will retained pay be guaranteed forever? Yes, but providing your circumstances do not change, the most obvious instance of which is a promotion, as stated explicitly in the final term. Question 7 adds the other qualification. The entitlement will change if the worker chooses a new shift pattern. Page 285, question 33, expresses the same things in different language. What does retained pay mean? It will remain for as long as you are employed in that role. It cannot be negotiated away collectively, etc. So to the wording which so vexed my learned friend yesterday, as long as you are employed in that role. That does not add to the promise that retained pay will remain a permanent feature of your contract. It expresses that promise together with its principal qualification. You are permanently entitled to retained pay for as long as you are employed, but not if your role changes, which is, of course, exactly what the retained pay term says. Retained pay will remain a permanent feature of your contract, but subject to you getting promotion. Just as if a booklet explaining Mr. Awan's entitlement had included the words, you will remain entitled to long-term sickness benefits for as long as you are employed and incapacitated. My lady, my lords, nobody would ever have thought that the meaning of those words is that if the worker's contract were terminated and he were then re-engaged either immediately or subsequently, that the entitlement to retained pay would restart, and the claimants have never argued that. Those two conditions for retained pay, for so long as the contract persists and for so long as you are employed in the same role, are not disjunctive. Both must apply. Or put another way, the entitlement ceases on the sooner of the termination of the contract or a move to a different role. So if the respondent dismisses a claimant, lawfully or otherwise, that brings the entitlement to an end. As in Awan, if the employer were to dismiss and offer re-engagement without the contractual benefit, the entitlement to the benefit ceases. And then the question is, was the dismissal lawful? If it was in order to deprive the employee of the permanent or long-term benefit, it would be unlawful. If it was for any other reason, it would be lawful. At 295, the joint statement promises that the retained pay is guaranteed for life. Does that mean that the entitlement continues after the contract terminates? No. Does it mean that the qualification to the entitlement set out in the other documents, including the finally agreed term, are of no effect? No. It just means that in that document, the message conveyed is that, subject to those qualifications set out in other documents, the entitlement is permanent, till death or retirement, unless one of the preconditions were no longer met. The same is true of 277. The document my learned friend said was of such little weight, and my learned junior points out it's interesting to note that the boxes below the first box are all time limited.
Sorry, which page is that?
277. I accept, of course...
Sorry to interrupt you, Mr. Siegel. The judge seems to have understood your case differently from the way you've explained it to us.
Yeah.
because in her judgment, if you don't mind looking at it,
No, of course.
the concern I've got about this at page 232, it's at the end of paragraph 40. She's talking about your interpretation where it's the benefit continues as long as the claimant's employed in the same role. And she's saying, so construed, there's an inherent conflict between the right to terminate the contract for the purposes of removing the right to retain pay in circumstances in which a fresh contract will be offered in relation to the same substantive role. So she seems to treat it as you're saying, well, the right will continue as long as you're in that role, even if the contract terminates and you're re-engaged. And of course that runs into the objection, which is what the Court of Appeal said was the answer to it, is that it would be extraordinary if Tesco were worse off by offering re-engagement than they were simply dismissing.
My lord is absolutely right.
And that's how the argument seems to have gone. And it's now you're making it clear, I'm sure correctly, that you're not seeking to say that your case should not be understood in that way, and that there's really no difference between what you say, how you express the length of the obligation and the respondents, except that you add the extra refinement that, of course, it doesn't continue if the role changes.
Everything my lord says, I have to agree with. I wasn't at the original trial. I simply note that at paragraph 46 of the judgment, the judge expresses it slightly differently and perhaps more consistently with the way I now put it. Just below G, once terminated, the contract is at an end. It is a matter for the former employee whether she wishes to accept any offer of re-engagement. The difficulty in this case lies not in the intention to offer re-engagement, but in the intention to terminate the original contract. For the
that's Mr. Carr's. That's what Mr. Carr's saying. Mr. Carr's objecting to the implication of a term which would have the effect of that. That's his argument.
Oh, sorry, I was misled by rightly objects to at the beginning of the paragraph. I thought the judge was accepting that part of the argument. I apologise if I've misunderstood it.
Well, it may be that she did accept it. Yeah. But it seemed to have been the argument.
I think, in fact, yes.
I think she is.
She is accepting it.
Yes,
right.
I think
I'm
my
so
learned,
sorry.
Yes.
Yes.
The remainder of the paragraph makes that clear. But
perhaps there's been an ambiguity in the case, but one could see why. Well, I could see why Lord Justice Bean thought that he was answering it by pointing out that, if as he did in his judgment, your case, that paragraph 36 of the Court of Appeal, that it can't be the case that there's no breach of contract provided they make an offer to re-engage, but there is if they don't.
My lord, like this court, I have the disadvantage, or perhaps the advantage, of coming to it fresh, and I would respectfully try and maintain an intellectual purity to my submissions, which is that that's what the words should mean, do mean, and if it's been suggested they mean something wider at other times, then I don't adopt those suggestions. So, only by reading the statements of the basic entitlement to permanent retained pay and the qualifications to it as separate, which would not only be unnatural and nonsensical, but inconsistent with the term itself, does the respondent contrive its supposed paradox. Page 266, the right of the claimant is that retained pay will remain a permanent contractual entitlement, that's the term itself we're talking now, subject to certain situations arising, one of which is a change of role. It could not be more simple. As to the rhetorical question posed by my learned friend, if the promise that retained pay will remain a permanent contractual entitlement does not mean only that it will not be subject to collective renegotiation, then where is that guarantee encapsulated? One answer was suggested by members of the court yesterday, that it was captured by the promises that retained pay is an individual entitlement, which is expressed 3 times in the retained pay term, and which corresponds directly, as my Lord Reid pointed out, with the language in the documents such as 272, question 8. Making retained pay an individual contractual entitlement prevents any possibility of it being subject to negotiation in the future, etc. But
just pausing there, that wouldn't have that effect, would it? The mere fact that it's in an individual's contract, if there's a collective bargaining machinery, that would override what was in the individual's contract unless there was some other promise. Is that right? So A8 looks as though it's wrong.
Well, I don't want to push it too far because I think there's a better answer, which was the one the court suggested this morning. But I do say that there is it's a construction point again, but I do say that there is a difference between, on the one hand, it is a term of your contract, and the other, it is, as it were, singled out as an individual contract entitlement, which in context, using the words as they would have been understood by the parties, bearing in mind the documents you've looked at, does in fact, I say, mean it can't be collectively renegotiated. But there is a more compelling answer,
Roman 1.
Which is the one put to my learned friend today. The guarantee that retained pay will remain a permanent contractual entitlement is subject only to the qualifications that follow, and collective renegotiation is not one of those. Indeed, as it was put to my learned friend, the matter is put, we say, beyond doubt by the first of those qualifications. Retained pay can only be changed by mutual consent. What does that mean? If it does not mean cannot be collectively renegotiated, my learned friend has not suggested an alternative. It is, we say, extraordinary how reluctant the respondent is to give the words of this term their natural meaning. Will remain a permanent contractual entitlement means, they say, can't be collectively renegotiated. Subject to means, and this equals, I suppose.
Means equal to.
Yeah, equal to. And only, in clause 1, means not only, or perhaps has no meaning. Leaving aside that the totality of the respondent's construction is obviously inconsistent with the explanatory documents. And note, the respondent's construction is entirely dependent on selected parts of those documents. In other words, if you just look at the retained pay term on its own, it's quite impossible to construe the guarantee that retained pay will remain a permanent contractual entitlement as meaning not subject to collective renegotiation. It's only by bringing into play the pre-contractual documents. So my learned friend is able to say, well, I posit this as what it meant because the pre-contractual documents talk in those terms.
Well, he accepts their admissibility.
Yeah, no, I understand. It's not an admissibility question. It's a you can't pick and choose point. If you're going to construe the entire essence of this term by reference to the pre-contractual documents, if your construction rests only on those, then you must take all of them, not just little bits of some of them. And as to my learned friend's answer to Lord Reid yesterday, that I think both Lord Reid and I tried to write down verbatim as he was speaking it, that the guarantee of permanence can be interpreted as a promise that, and this is my note, so far as they have a contract with retained pay, that entitlement will continue. That is a tautology. Every contractual entitlement is guaranteed for so long as a contract continues with that benefit provided for. That promise would have no substance. So having disposed of the supposed problem in construing the retained pay term, it is the guarantee that retained pay will remain a permanent contractual entitlement which requires a term to be implied to limit the unrestricted power to dismiss for any reason, to give that guarantee substantive effect. The qualification that the entitlement may cease before that time if the worker's role changes, whether or not that would require a new contract of employment, does not require the implication of any limit on the power to dismiss. So almost the entirety of my learned friend's submissions on the construction of the retained pay term and whether it's necessary to imply a limit to the power to terminate were predicated on false premises and directed at an illusory target. I therefore reiterate, and this sounded twice during the course of this morning as though it wasn't going to be controversial. If the claimant's construction of the retained pay term is right, it must follow that the limit on the general power to dismiss needs to be implied. That was a concession made in terms, as I heard it anyway, both to my Lady Simler and to my Lord Burrows. And the scope of that implied limit, as in Hyman, the PHI cases generally, is simply, to quote Lord Steyn, that the general power must not be exercised in a way designed to deprive the relevant guarantee of any substantial value, or, as my lady put it in our one, on the grounds of the entitlement to the long-term benefit once the worker became entitled to it. In that case, triggered by incapacity. In this case, triggered by foregoing the redundancy payment and moving 40 miles. And as in our one, such a term is capable of sufficiently clear expression, leaving aside for the moment the issue of the wording of an injunction. And in order to engage with the officious bystander, I remain content to formulate the appropriate question with the utmost care, along the lines canvassed with my Lord Legate. Is the guarantee that retained pay will remain a permanent contractual entitlement consistent with Tesco's right to dismiss and offer to re-engage, or just to dismiss in order to remove that entitlement when it was in its commercial interests? Tesco says it must be allowed to remove retained pay. Otherwise, it may face a huge increase in its exposure to equal pay claims. The claimants say that the agreement of the retained pay term and its consequential limit on the power to terminate would constitute a material factor for the purpose of defending those claims. And it is striking that after a decade of those claims, the claimants have not named workers in receipt of retained pay as comparators, despite the prominence of this litigation. My learned friend disagrees. So be it. If he is right, then it appears Tesco made a bad bargain in 2009, which with proper legal advice it could and should have foreseen. But as we know from paragraphs 19 and 20 of Arnold and Britton, that is no basis for depriving the words of that bargain of their natural meaning at the time the agreement was made. In terms of the question, is there inconsistency? The inconsistency is not, as my learned friend began by suggesting, between the meaning of two express terms. There is no such inconsistency in the PHI cases. The inconsistency is between, on the one hand, the substance of the guarantee of a permanent or long-term benefit, and on the other, the unlimited power to determine the contract, even in order to deprive the employee of that permanent or long-term entitlement. It's exactly the same in the present.
But isn't it an inconsistency between two express terms then, but properly construed? Doesn't it have to be?
It does, but what maybe I misheard or misunderstood my learned friend, but the meaning of the words of those two express terms are not per se inconsistent. It is the ability to exercise a power granted under one express term, which in a particular circumstance is inconsistent with the substance of a promise made by the other. And if I'm being pedantic, I apologise, but that, because my learned friend raised the point, I thought it was right to at least articulate the claimant's case as precisely as possible. And that is completely different from the Reader case. That case had very unusual termination powers. The powers were to dismiss summarily note, for specified different reasons. One, for cause, in other words, misconduct. Two, for unsatisfactory performance. And three, for no cause. And the term provided for different financial consequences on the exercise of those three different powers. And the most generous, in fact, to the claimant, unsurprisingly, being an entitlement if the dismissal was without cause. And that was the power the defendant exercised. It's an a fortiori analogue of the Christian Salveson case. There had been a careful compromise between the parties in respect of competing objectives, as it were, and there is no scope for implying a term to supplement, let alone, and this is why it's a fortiori, to contradict those terms. It's very much an outlier in respect of both the wording of the term and the analysis. In relation to the injunction issue, my learned friend says that it's not all about confidence. He used words like it's relational, there may be friction, there may be mistrust. Those seem to us to be rather variants on the theme as opposed to different propositions. Certainly we agree that the relational aspect, the need to avoid friction or mistrust, is part of the rationale for the general rule. But the respondent, and I understand my learned friend was pressed for time, but the respondent did not address any of the statements of principle in the various cases to which I took the court yesterday. My learned friend says if you look at the 4 cases in which a final injunction was either ordered or foreseen, the terms in each of those 4 cases were rather different from the injunction that the trial judge ordered in this case. That is true. Because in each case, the unlawful act that is threatened is a different act. And so in each case, the terms of the injunction that were ordered addressed that particular threatened unlawful act. That is all we're asking should happen in this case. The unlawful act that is threatened is to terminate the claimant's employment in order to remove retained pay. They can't do it tomorrow, they can't do it the day after, and if the claimants are still employed and the distribution centre still exists and the claimants haven't taken promotion or chosen different shift patterns, they can't do it in 30 years' time.
The precise problem is firing and rehiring. I take it that you would not think an injunction that was specifically directed to that would be a possibility.
Well, my lord, the problem with dealing with so many of the respondents' submissions in this regard is they're all so artificial. Would the respondent dismiss a group of people and not offer them re-engagement if the only reason to dismiss them was because they were in receipt of retained pay? The obvious answer that everybody knows, including Tesco and its legal representatives, is no. So, in theory, what would happen if Tesco dismissed them and didn't offer them re-engagement on the same terms as all of their colleagues, which could never in the real world happen? But yes, my answer to that is it would be contractually unlawful, just as it would of course ground a completely unanswerable complaint for unfair dismissal. So the position of principle that the claimants advance is that the injunction should restrain the Tesco from dismissing in order to remove or because the claimants are in receipt of retained pay. In practice, of course, in such a situation, they will always offer re-engagement. My learned friend says that cannot be right because what a burden that would place on the business. And clarified in answer to my Lady Simmer's question, that meant the potential for additional equal pay damages. Which strikes me, if I understood it correctly, to be a submission that a party cannot be held to a contract by an injunction if it turns out that the promise it has made was a very bad bargain. And I know of no authority to support that proposition.
Well, those damages are meant to compensate. If they'd have to pay the damages anyway. If the damages do their job, they'd be just as bad, have just as big a burden.
Well, I think my learned friend's point is, and it's rather shutting the door after the horse has bolted, but I think my learned friend's point is, if in the future I can't remember the number he gave, but some or all of the 40-something thousand equal pay claimants
I see, yes.
decided to name the claimants as comparators,
Yeah.
and if the respondent Tesco to such claims were not able, as we say it obviously would be able, but I understand my learned friend disagrees, were not able to pay the retained pay term agreement and the decisions of the courts that it would be unlawful to terminate, to get rid of it, in aid as a material factor, which I hope I don't have to explain would be the most likely outcome, if not the inevitable outcome. But if that happened, then Tesco would face, we are told, potentially a bill of, let's say, 130 million instead of 100 million, because the comparators would be paid 30% more than the presently named comparators. And so what my learned friend says is, you can't injunct us when it could cost us 30 million. I know of no authority to support that proposition.
Well, it's also difficult because this is all off the page, as it were. Nothing was said in the letters that's got anything to do with the reason why they were dismissing them. It may have been in the background, but
I'm not sure that, to be fair to Tesco, I haven't gone back recently and looked, but I think it is right
there is something referred
to say that Tesco was transparent to some extent in the period of negotiation or consultation about the equal pay issue being part of the reason for what they were doing. I think that is right, but I can't take it to the pages because I haven't looked at them for a long time.
And do they have some evidence about what the consequences would be in terms of the equal pay claims?
I only know what you've heard from my learned friend, together with knowledge of an employment lawyer who talks to other employment lawyers about the fact that there are a large number of equal pay claims against Tesco's that have been going on for a very long time, and that they don't cite these claimants as comparators. So that's all I can tell you. But I know nothing to suggest that what my learned friend has told you is in any way inaccurate. And if he says that there are so many thousands and that they're exposed to so many millions, I take that as right. A couple of words about Powell. My learned friend said Powell isn't about dismissal, the removal of someone from a role in order to place her in a lesser role is in law a dismissal. That's established since at least the case of Hogg and Dover. But in a sense it doesn't matter, because what matters is how the Court of Appeal in Powell treated the proposed unlawful act, and how the court treated the injunction it was giving. It, in all the judgments, dealt with it as if it were a dismissal, and even in Lord Justice Ormrod's judgment, importantly, dealt with it as if it were an order for specific performance of an employment contract. And that's the reason why both of us are referring to this case. So, yes, it is absolutely a case on point. Can you injunct so as indirectly to order specific performance of an employment contract on the terms that the employee presently enjoys, as opposed to the lesser terms that the employer wishes to impose? That is that case. That is this case. Was the injunction ordered? Yes. Was it foreseen that it would be ordered at trial, and was that a reason for ordering it on an interim basis, as I hope you saw yesterday? yes. Argyll at 1658A, my learned friends asked you to look at the case in more detail. I'm happy, obviously, that should happen, but I suggest that the robust language used at the top of page 1658 encapsulates the reason why relief was not granted as sought in that case. Not only would it be a waste of resources, but it yokes the parties together in a continuing hostile relationship. That is many miles from this case. So for the reasons given yesterday, I maintain that the injunction ordered by the judge was just and convenient. There is no basis to interfere with that discretion, and it is sufficiently precise.
What do you say about the point that was made that the judge at first instance does appear to have relied on the cap on unfair dismissal when there would have been an uncapped wrongful dismissal claim on your case as the basis for ordering the injunction, and that was an error, and therefore the Court of Appeal exercised its discretion, and for the same reasons as you argued yesterday, we shouldn't interfere with the exercise of that discretion?
It's a fair point. I don't accept that it was the reason why the trial judge ordered it, but it was a part of the trial judge's reasoning. I have to accept that.
And it was an error?
Was it an error? Yes, because although that was the way the case had been put, that wasn't part of the respondent's case the defendant's case as it was then, that she accepted as correct. Whether I am in the same position as the first appellate court in asking you to reach a different decision to the Court of Appeal, I would respectfully suggest not. But I have to accept that to the extent that the Court of Appeal challenged that part of her reasoning, it was right to do so.
Do you say anything about another principle that was briefly referred to, which was mutuality? So the argument is you can't get specific performance against an employee, therefore it doesn't work the other way around, the principle of mutuality. Have you anything to say about that?
Well, I say only that every case that has considered it and every textbook that has written about it recognises that there are different principles that govern the two different aspects of a potential requirement for the relationship to continue. And I think both Chitty and Snell say in terms the reasons why you cannot force an employee to serve do not apply to the reason why, in general, or in the ordinary case as it's put, you cannot require an employer or a master, as it was in those days, to continue the relationship. I also maintain that in a situation of genuine doubt, the respondent does have recourse to the courts to apply for a declaration or to vary the order. The El Husseini case involved an attempt to secure an interim ruling in relation to whether an act had been done in breach of an undertaking which the court had no power to vary. It was a completely different scenario. They were asking the court on an interim basis to say that Joan was in contempt. And unsurprisingly, the court said, well, of course we're not going to do that. We're not going to make a contempt finding without all the normal procedural and evidential safeguards that would be required before such a finding could be made. That contrasts with the situation where parties seek a declaration as to the lawfulness of intended action, which the court does have jurisdiction to determine, does often determine, including in employment cases involving potential redundancies, which is one of in fact, the only real situation my learned friend described as problematic. I said that the case we relied on yesterday was Rolls-Royce and Unite. I now have the reference for it, 2010 ICR 1 per Lord Justice Aikins, and the relevant principles as to when the court will accept that jurisdiction are set out at paragraph 120. I haven't got the case for you now, but I respectfully submit that all of those principles would be satisfied in this case. However, which brings me to the last substantive point. If the court is against us on those points, and it is persuaded that my learned friend's hypothetical example might be problematic, not a view shared by Tesco's previous counsel, then the claimants would be content with clauses being added to the injunction in the normal way to clarify the situation in the event of multiple redundancies hypothesised by the Court of Appeal and, differently, by my learned friends, as the potentially problematic situations. It would be, dare I say, child's play. Clause 1, in addition. The respondent would not be in breach if it closed down any distribution centre, making all of the workers there redundant, including any number of affected workers. Clause 2. The respondent would be in breach of its terms if, in a redundancy situation, it included as a criterion for selection whether the worker was in receipt of retained pay. As with the grant of any injunction, as was implied by one of the court's questions to my learned friend, as soon as the parties identify a potentially problematic circumstance, they cooperate with the court to cater for it in the way the order is worded. This case should be no different. I note the time. I have a minute or two I was going to use to speak about the unfair dismissal issue, but if time is up, it is up, whichever the court prefers.
Dismissal, do you? No, we don't need to hear you on that issue. Thank you, Mr.
I thought probably not. Thank you, then.
Well, we're grateful to counsel for their submissions. We'll take time now to consider them and let you have our judgment in due course. In the meantime, the court will adjourn.